Law Bulletin Publishing Company is the oldest continuously owned company in Chicago, privately held by the McFarland family since 1879.
I joined the news business because it can be exciting and it changes every day. I sort through contradictory and confusing details of events and give readers the truth to the best of my ability.
I enjoy particularly interviewing lawyers and judges along with law students and telling their compelling stories.
I've never wanted to do anything except work for a newspaper. It means I get to tell stories every day that matter, and it's a job where I'm constantly learning.
You get the chance to learn every day. On top of that, you get the chance to hopefully tell people in an entertaining and somewhat thought-provoking way the things you learn.
The internet has certainly had an impact on the news industry. Newspapers will continue to evolve as the technology changes.
I'm so excited by all the innovative ideas that we're implementing right now in the Law Bulletin. We have the hardest working staff in the business, and we like to think outside the box and think of new creative ways to cover the legal community. That makes my job fun.
Well, welcome to our inaugural video of This Will Only Take a Moment. I'm here with Dan Webb, who's the chairman of Winston Strawn, a leading litigator and trial lawyer in the Chicago legal community. And we're going to talk a little bit about best practices to being a lawyer. So I guess to kind of start, I guess when preparing your opening or your closing, what are you kind of keeping in mind to make sure that you're getting across what you want to get across?
Olivia, I think what I'm normally trying to get across is I started the case with a simple framework. I have to always find a simple framework in which I can market and sell a case, no matter how complex the case is, no matter how difficult the case is, no matter what the facts are. You cannot market and sell a case unless you find a simple, straightforward, common sense framework in which you can fit all your evidence into. So by the time I get to do an opening statement or a closing argument, with a mass of information, I'm trying to fit it into this framework. And I'm recognizing at the same time that I am a salesman. That's what I am. Lawyers sometimes have an elevated view of what they are in life. They are a salesman. You're marketing and selling a product in an unusual environment in a courtroom where we're recreating a past historical event that may have taken place months or years ago, and we're trying to market and sell our view of that case. And so we are salesmen. When you're a salesman, though, you learn when you make a sale that you have to keep things simple, straightforward, and so I'm constantly working on that. I start the case with an opening statement in which I lay out a framework. Simple themes, a simple framework, simplify the issues, and make sure they understand this is what this case is about, and everything I'm about to tell you over the next month, 3 months, 3 weeks, whatever it is, I've got to find a way to fit it into that framework. And so that's what I'm constantly trying to find a way to fit it into that framework during the course of the trial.
Okay. So what's the number one lesson you've learned about being effective?
I think it's that, okay? I mean, I try a lot of very complex cases, patent cases, commercial cases, as well as simpler cases. And I've learned over the years that jurors can only assimilate so much information. You cannot overburden them with too much information. You may find yourself during a complex trial, they will accept and understand details, but you need to provide for them this simple, straightforward issue, framework, structure of the case where everything is going to fit into that, so that I never forget that, from opening statement all the way through direct exams, cross exams, closing arguments. I'm constantly coming back to this framework that I've crafted for the jury based on my view of the case, because at the end of the day, what I'm trying to appeal to is common sense. And it doesn't matter, it could be a complex patent cases involving difficult engineering concepts, but at the end of the day, I have got to be able to convince this jury. They have to believe they understand it. If they think they don't understand it, they will not rule in your favor. And so my job is to make sure that no matter how complex it gets, I am not going to let them ever believe they don't understand it. And I'm going to find ways to simplify it and fit it back into this framework I've given them. If I do that, they'll like me. I want the jurors to like me. And I want them to think, that guy Webb worked hard at making us understand the case. And I know that if I do that, they'll like me. If instead, people don't like to feel inferior. People don't like to feel like, wait a minute, I don't understand what they're trying to tell me, and then they start to resent. They start to pull back, and they don't want to be in the game with you because they don't think they understand it. So your job as a trial lawyer is to always make the jurors believe, I do understand what he's telling me, and it fits into this little simple framework that he gave me. Now, I know there's a lot of complexity, a lot of details that I may not understand all that, but what Webb told me, I can see how this case fits into that, and then they like me, and then they rule in my favor, and that's what I'm trying to accomplish.
So what's your number one pet peeve when it comes to opposing counsel?
You know, I don't have my number one pet peeve is occasionally you find opposing counsel that take it too seriously and they forget what I call civility. We are lawyers, and there's a lot of things that happen during a trial that require you to cooperate with each other, to share information, to make sure that you're making sure this trial proceeds smoothly, logistically, and I hate lawyers that take this kind of standoffish, we're just going to fight you in the courtroom. We don't want to cooperate, and that's just ridiculous. And so it doesn't happen a lot, but every once in a while you run across a jerk who, and I hate it. I just hate working with them. In fact, the trial's no longer fun. Right. I love trying cases. I enjoy, and I like being. I don't dislike my opponent. In fact, a lot of times I become close friends with my opponents because we're trying to make sure that something called justice occurs in a courtroom, and we can be civil and cooperative with each other and still fight like the devil in front of the jury. But it doesn't mean we can't be civil and cooperate, and I hate it when it works out the other way.
So what gets your adrenaline going in the midst of the trial?
Probably cross-examinations. They're different than everything else. Everything we do in the courtroom, you try to plan out, you try to prepare, you try to master, because he who masters the information does best in the courtroom. It's easy to master an opening statement. You just prepare it and you get up and deliver it. Same thing with closing argument. It's all, you prepare it in advance and you deliver it, you perform. Direct examination is a lot that way because you can prepare it and you can deliver it and follows a game plan. Doesn't mean you don't, it's still got some skill involved in it, but it's done. That's not true of cross-examination. While we prepare really hard to do great cross-examinations, that human being on the witness stand is not going to do what you want that human being to do, because that human being is your enemy. That person has been prepared to hurt your case, to damage your client's interest, and so what gets my adrenaline going, if I get up in the morning and I start shaving and I have a good cross-examination to do that day with a tough witness, I can feel my heart start to race pretty early in the morning, because that's the most skillful, challenging thing we do as a trial lawyer, is facing the enemy head on in this give and take of a Q&A. And with a lot of preparation, you have to find ways to control the witness, to make the witness appear non-credible in front of an audience. And there's so much going on, and it's always unpredictable. You never know exactly what's going to happen. Witnesses take off in strange directions where you are completely surprised by what happened. You have to be flexible, you have to know how to deal with it, but you can never forget the audience, which are those 12 people watching you perform in a difficult circumstance. So that gets my adrenaline pumping a little bit.
Sounds fun. Sign me up.
That's what makes it enjoyable.
So how has e-discovery kind of changed this process?
I don't know. Well, first of all, the discovery, it doesn't really change the trial, because whatever you gather in discovery, you got to find a way to mold it, fit it into your structure, and make it work. And so the biggest impact, probably the biggest impact e-discovery has is that the existence of emails, which are moment-to-moment thoughts of people, have changed the landscape of litigation. The reason they have is because before emails, people had a right to tell you what they remembered happening in the past. And they're not always locked in based on a day-to-day document trail on any given issue where you're exchanging your views and thoughts in writing with 12 people. But once you've done that in the real world, when we go back and try the case later, and we try to recreate this past historical event, we have emails create more bad documents. We try cases and win cases because we're trying to minimize and avoid bad documents. Emails create a pool of more bad documents because they memorialize what people said or thought at the time, which may have not been completely accurate, and so it creates more of a paper trail that makes our life more difficult as trial lawyers and kind of finding a path to follow so that we can explain a case to a jury and not be burdened with a documentary trail, which when people just pick up and start typing out random thoughts every day, they often are wrong. And yet then later trying to explain those becomes more challenging in the courtroom. So the more bad documents that get created during the course of the creation of the historical event, the more difficult it is for the trial lawyers to find a path to follow.